addition, it may give others. Yes.
Is it okay to ask questions?
Certainly, certainly.
Is it wise for a clerk, if there were 4 assembly members to go to a celebration of a retirement, to announce that there is a public meeting where you may have 4 other assembly members attending?
That is a conservative approach which many clerks choose to use. There are some cities, some boroughs where usually they'll just do it for a public meeting. For example, if DOT is coming to town and they're going to do a presentation on a project, or if Lisa Murkowski is coming to town and there may, such and such event, there may be 4 or more assembly members there. Just a notice in the paper. That's a conservative approach. It's not critical, but you've given notice that these folks may be there, and so if you want to keep an eye on them, then you know what's going to happen. But I don't believe that's one of those areas where it's sort of a judgment call. I don't believe it's mandatory, but it is a legitimate conservative approach. If it's an event, one of the differences also is if it's pre-planned or that they're going to be going to this thing. If you all happen to show up to the same basketball game, there's no way to notify that. But if it's an event that's open to the public and that there's likely to be 4 or more of you there, if you've got a standard ad space in the paper that you're using, you can just put a notice in there. And that's a good conservative approach. Other examples of what might be a meeting: serial telephone polling, emails. If there are emails, and I think most of the clerks are pretty good about this, you're blind copying assembly members or planning commissioners so that if somebody hits reply, they don't accidentally hit reply to all. Reply to all is not your friend. Because a couple people hit reply to all, and pretty soon everybody knows what everybody else thinks, and you've had this meeting out, so you've collectively considered the matter outside of a meeting. So using blind copy for sending things out, having communications go through the clerk. Now, in the public records section, I'll talk about that. It's not a bad practice because then you don't have to worry about your own devices becoming public. So the big question is collective consideration of something you have the authority to decide as a group. Who does it apply to? It applies to all meetings of a governmental public entity, any official board or commission. It doesn't apply to staff groups. If the manager wants to have a review committee for an RFP and includes an assembly member and a planning commissioner on it, it's a staff-formed committee. It's not going to be subject to the rules. If the mayor appoints a blue ribbon committee of 3 to look at something, that's going to be a public committee subject to the rules. Yes?
Scott, I'd like to ask a real-life question pertaining to Kodiak Borough. The Assembly created a consolidation committee to research and discuss the possibility of consolidation between Kodiak Borough and the city of Kodiak. I believe that committee is advisory because any decisions, any recommendations would go to the Assembly to make a final decision. Within that committee, 2 or 3 members volunteered to work together on creating a budget structure for a consolidated effort. There was some question brought forward on whether the meeting of those people to create that budget document needed to be noticed under the Open Meetings Act.
Well, that would be one of those where reasonable minds could differ. I think there's a pretty good argument that it doesn't, but in part it depends upon how it's formed and what their function is. Are they being scriveners or are they being policymakers? Are they an official designated subcommittee or are they just an ad hoc gathering of a couple folks who are on the committee said, okay, we'll put together this draft. It's not a violation of the Open Meetings Act for, let's say one assembly member has this piece of legislation they really want to pass. They can call each other assembly member and lobby them for it and talk to them individually. They could have talked to all of them. What they can't do is act as a conduit for communicating the information amongst them so that a majority of the group has heard it. So you could have two assembly members working together on some legislation, you got no problem with it. If you have a consolidation committee of 7 people, if 2 of them are working together on something, that by itself isn't going to be a meeting. But if the chair of the committee says, I'm appointing a committee of 2 to do such and such, make these decisions and report back, that's sounding more like an official subcommittee that might be subject to the act. If it's just you 2 work together and report back, if they're making some decisions as a group of 2, it looks more like a committee, subject to public notice. If they are just putting together a draft for consideration by the committee, then are they really making decisions, or are they just doing some staff work because there's no staff for the committee? I could argue it either way.
Thank you very much.
Yeah, piggyback off her word, same committee. It's essentially gathering information to bring back and like, hey, this is what it would look like. No decision making. It's just instead of wasting all the time in the committee talking about the budget. Hey, and the chair didn't appoint anyone. People volunteered for this subcommittee to gather information, put it together, and then bring it back. And what we ran into is someone said, well, I think you're violating the Notices Act. And it threw a wrench in there because it was like everybody's got different schedules and whatnot. And, at the last minute it could be canceled, or it's like, hey, I got time. Do you want to work on this?
Yeah. You cannot insulate yourself against potential criticism in that scenario. The scenario you described, I don't believe the 2 people would be a meeting subject to the Open Meetings Act. But if you want to sort of insulate yourself, one of the there are exceptions for the Open Meetings Act, executive session and such, but there are also what are the requirements? Your basic requirement is notice of the time, date, and place of the meeting. And the notice needs to be given, it needs to be reasonable public notice, sufficiently in advance that somebody might get it, and it should be given in a consistent manner. So if the method for noticing your meetings is we post it on the city website, well, if those 2 are going to be getting together, say, we might be getting together Thursday, and you post that on the website, maybe you get together, maybe you don't, but there's notice out there that you may be working on something. And that's, if you're going to be doing it in a public location. If you're doing it at your house and you're not an appointed committee, I wouldn't bother with a notice. I mean, people can be critical, but for an advisory board, getting into the remedies, you're not elected, they're not going to recall you from office. The remedy, somebody has to bring a challenge within 180 days. If it's advisory only, there's not a whole lot of difference. The remedy is generally a full and fair reconsideration of the issue, whatever the decision was that was made. And if you're not making a decision, then it's, the decision is going to be made in the public meeting. You don't want a majority of that consolidation committee to be communicating and deciding out of the public meeting. But to the extent that there might have been some violation, when the whole consolidation committee gets the information, debates it, and decides it, that's your full and fair reconsideration of the issue at a public meeting. So you've cured, whatever gets adopted, you've cured the invalidity. And that's one of the, there's the process part of it. You want to get the process right. There's the the enforceability or validity part of it about what the action is you're taking. And that's where, if you're adopting an ordinance or approving a plat or, some tangible decision, you want to make sure that that was done properly. You're a little more concerned about making sure the notice is right and everything. If it's advisory and it's sort of pre-decisional, okay, the remedy is we gotta have a full and fair consideration of the issue at a properly noticed meeting. We didn't think it required it, but it's going to be solved anyway. And you can't prevent criticism, but you can acknowledge it and say, you know what, don't worry about it. We don't think there was a violation, but even if there was, it's going to be okay. We're going to take care of it. So what are some of the exceptions?
Thank you.
Yeah, no problem. Executive sessions, the purpose has to be identified in the motion to go into executive session sufficiently for someone to determine whether it meets one of the exceptions. So if it's to discuss the character and reputation of a person, that if the discussion was held in the open, it might prejudice their character or reputation. Generally, you identify the person, or if it's a person's position. The person doesn't necessarily have a right to be in the executive session, but they have a right to notice in advance of it and to require that the discussion be held in an open session. Most of the time that this comes up, it's, there are two main times it comes up. One is annual evaluations for clerk and manager. Then usually, at some point, you want them in the executive session to give them the feedback. The other time it comes up is in a hiring process for manager, clerk, attorney, something like that, where you're going to interview candidates. Well, those interviews probably are going to be an open session, but after the interviews, when you want to talk about people, if they're courteous, they're going to let you go ahead and have the discussion in executive session. If they're jerks, they're going to say, oh no, we want it to be an open session. But you also could say, well, matters the immediate knowledge of which could adversely affect the finances of the borough, because if candidate A knows that everybody loves them and they've got it in the bag, they're going to drive a harder bargain when you go to negotiate. So the finances is another justification for having an executive session discussion about qualifications of applicants for a job, or the relative merits. Does the executive session have to be listed in the published notice of the meeting? Generally, I advise, if you know you're going to have an executive session on a topic, do it, particularly if that subject matter is not on the agenda otherwise, because if that's the only time you're going to talk about it, you need some notice on the agenda. But if there are topics at a meeting that are on the agenda, and you're going along and you realize, oh, wait a minute, we don't want to talk about how much we're willing to pay for that piece of property in open session, can you go into executive session, or do you have to wait until the next meeting and then advertise it again? I've advised that generally I think you can go into executive session if the topic that you're going to be discussing is on the agenda for the meeting. Now, the notice that's required, I mentioned that it has to be time, date, and place. The question of how far in advance the notice has to be and how detailed the notice has to be, it varies with the significance of the issue. The more controversial the issue, the more notice is probably required. The case dealing with this, Tunley versus, I think it was versus Municipality of Anchorage, but it may have been the school district. They were closing some schools in Anchorage, and they gave 5 days notice before the meeting where they made the decision which schools to close. And the parents weren't happy because that was not very much notice. And the court said, in view of the significance of the issue, the notice was inadequate. So if an issue is significant or controversial, err on the side of giving more notice. If it's a minor thing that's, it's not spending a bunch of money, it's not going to significantly affect anyone's rights, then less notice is probably required. And this comes into play in the detail, too, because the statutes don't require publication of everything that's on your agenda. Now, if your practice is to do that, keep up with the practice. If there's an ordinance, when you, prior to public hearing, you have to have a 5 days notice that sort of gives a summary of what the thing's about, that there's going to be a public hearing. That's a separate notice requirement. But if you have a service area board meeting, you generally don't need to put your whole agenda in the paper. If you do, you're probably wasting your money. If your standard method for announcing service area board meetings is you post it at the clerk's office, you put it on the borough website, and that's what you do every time, and you don't have the detail of the agenda, but if anybody shows up at the meeting, the agenda's right there, that's probably adequate for a service area board. Unless you're talking about buying a new fire station or terminating the service area board, then you might want to provide a little bit more notice. But for routine meetings, the key is time, place, location. If it's going to be teleconferencing facilities, and have the method of notice be consistent. When in doubt, provide the notice. If you're planning commission or assembly and the routine is that you publish the agenda items, keep doing that. But if that's not the routine method, then you don't have to do that. In the materials, I had a bunch of sample motions for going to executive session for various purposes. Let's see, other exceptions. If the body's acting in adjudicative capacity, Board of Adjustment, sometimes there will be a provision that has an appeal going to the Assembly. Planning Commission often is in an adjudicative capacity. When you're deliberating, you can have it be closed. Quite often, though, it's nicer for the public if it's open. One of the things on adjudicative capacity, you have to be concerned about ex parte contact. If you're going to have something come to you, adjudicative is where you're taking the facts of somebody's particular situation and applying the law to the facts. Somebody's got a permit application. You're deciding, does this permit fit the thing? You want to avoid receiving information outside of the meeting that's pertinent to that decision. If you happen to, you should disclose at the beginning of the meeting that you've received this information and what it is, so the applicant or people opposing the application have an opportunity to respond. So you want to avoid the ex parte contact. Sometimes you can't help it. You ran into somebody in the grocery store and they're yammering at you. You can't unhear what they heard. Well, disclose, and the other people get an opportunity to respond. The other consideration in adjudicatory decisions is bias. The question is, can you be fair, or are your thoughts on the issue so strong that it doesn't matter what they say, you're going to be against them? It's your ex-brother-in-law, and just there's no way that you're going to help him out with anything. If you have an impermissible bias, or if you can't be a fair adjudicator, then you should disclose that and not participate. The financial interest part, I'll get to that with a conflict of interest. Let's see. I talked a lot about what notice is required. I and about notice for executive sessions, listing it on the agenda. Public participation. For the assembly, there's a specific statute that says you got to have something on your agenda, the public gets to speak. School district statutes don't have that. Planning commission doesn't necessarily have that. I don't recall if the Borough Code for Planning Commission does. It's a nice practice, though. But usually it's for comments on things that are not public hearing items, because Planning Commission is a bigger deal. If you have a Planning Commission case for subdivision X, you want the testimony to be compact on the public hearing on that item. You don't want them getting up in public comment talking about this plat and how they don't like it, because it's going to mess up your record. So the public comment should be on things that are not set for public hearing. If it's a public hearing item already, sorry, wait, public hearing's coming up, can talk at that time. Remedies for violation, I mentioned that challenge has to come within 180 days. Actions of advisory boards can't be voided so long as the body doesn't have authority to make the decisions or establish policy for the municipality. So, service area board, you're voting on the budget. Well, yeah, you're voting on the budget, but you're voting on the recommendation for the budget for the assembly. The assembly actually has to formally adopt the budget. So would that be a violation? Even if it was, your recommendation is not going to be void. It's better to do it at open meeting. You want to comply with the Open Meetings Act. But if it's not a legislative type decision, then it's not going to be void for the violation. Regulatory or legislative bodies, it's voidable but not automatically void, and there's about 9 or 10 factors that a court might look at. What bad things could happen, is too much time gone by, how significant was the violation, how significant was any reconsideration, has it been reconsidered, how obvious was the violation, how blatant was the violation, that sort of thing. And that's pretty much what I have on the Open Meetings Act. I'm sure there are some questions.
Excuse me, I'm curious what you said earlier about serial meetings. So an assembly member calls out an assembly member to the lobby for a particular vote. I was told that would be a serial meeting and a violation of the Open Meetings Act. If you indicated it wasn't, the caveat would be interesting.
The caveat is, okay, I want you to support me on this budget amendment to add $100,000 for buying a new truck, whatever it is. I call you and I say, this is a good idea, should support it. I call Joe, I say, it's a really good idea, you should support it. I can't say to Joe, I got one vote, you're going to be number 2, because if amongst us we know that we've got the votes, we have collectively considered it. If I know I've got the votes, we haven't collectively considered it, I've done my lobbying. So the part that you don't want to communicate is what other people's views on the issue have been in their conversations with you. Now, I'm not saying that that's the way you should do business all the time. I'm saying that I don't believe it would be a violation to call and lobby the individual folks.
So it seems like it would be similar to telling the public that when 4 people in the assembly met for coffee, that they didn't discuss the issue and infer it. It seems like, given what you said, that judges look at almost perception of what you were doing when they make decisions by allowing it to go, say, for a recall.
Yeah. The one thing about a recall is the trier of fact, the party who determines whether in fact you violated the Open Meetings Act is the voter. The people with the petition, they only need to allege facts that would constitute a violation. They could allege that you called and had a serial meeting with 3 other assembly members and decided this. And that might be enough to get the petition on the ballot, and the voters would decide whether it's true or not. And it may not have happened at all. But yeah, it's good to be sensitive about it, but somebody saying, oh, I want this public policy initiative to move forward, therefore I can't talk about it, is illogical. I mean, why shouldn't you be able to lobby your compatriots? But you can't lobby them in a way that violates the Open Meetings Act. And you can't do it on adjudicative things, only legislative things. Are there other questions? Yes.
Could you talk a little bit about the difference between, I know it goes on regular meetings and votes and it's all part of the public record, but then, let's say Borough has a work session, which also meets open meeting act, but from what I understand, there's no votes taken, and that the public can actually comment on something that's on the agenda, because that's the only time that they can talk about, which is different than what you were talking about before in a regular meeting, that the audience can talk about something that's not on the agenda.
Yeah, a work session is not a public hearing, so the public comments could be on whatever topic. And it doesn't have to be on something on the agenda either. They can talk about anything.
But it meets the Open Meetings Act, because
The work session?
you're going to have the majority.
Yeah.
present.
If the meeting has been noticed in a routine manner, the time, date, and location, then that's a legal meeting.
Right, like tonight, I mean, there's an executive session,
Mhm.
and then following that, there's going to be a work session.
Yeah.
You can see that on the Borough website.
Yeah.
Great, you got all the information. You just have to know when the executive session ends, we don't know.
Yeah. Yeah, if the assembly has published and listed the items on the agenda, they shouldn't take up another one unless it's just to say, you know what, let's talk about this at a later meeting.
Or to call it a special meeting, just to talk about the 2 issues that are going
Oh,
to be executive
but,
tonight.
yeah, but that's separately advertised. What I'm saying is on the work session, when they get to the work session and they have the agenda items,
Yeah, because after.
yeah. But even then, if they wanted to talk about burning the bridge down or something, it's not on the agenda, so they couldn't decide to do it. But they could say, well, hey, we should have this on a future agenda, and that's not a problem. The conflict of interest was the next one. Again, you know, like open meetings, public has a right to know, conflict of interest. The focus is on financial interest, and the public servants are expected to conduct the public's business in a manner which is not influenced by their personal financial interests. Now, strong opinions